Dear students, in this session, I will discuss goods and their classification. The meaning of goods, as per the Sales of Goods Act 1930, Section 2, Subsection 7, means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to or farming part of the land, which are agreed to be sold before sale and under the contract of sale. All these are included as the goods in the relevant law. Land is not included as a goods because there is a different law, Transfer of Property Act, for the sale of good, for the sale of land. So goods means everything, every type of stock, actionable claims which we can transfer to other person, growing crops we can sell to other person, grasses and other things which we can cultivate and sell to the prospective buyer in future date. Now there is next topics, classification of goods. Goods may be divided into three types. Basically, in three types. First one is the existing goods, second one is the future goods, and third one is the contingent goods. Now we will discuss all type of goods one by one. First is the existing goods. As per the section 6 of the Sales of Goods Act, existing goods are those which are owned or possessed by the seller at the time of contract. It means, as name suggests, existing goods are those type of goods which are available at the time of contract and possessed or owned by the seller, and seller can transfer the goods to the buyer. This is called existing goods. For example, I'm visiting a grocery shop for purchasing sugar. That the owner of grocery shop keep the sugar in packets and deliver to the customers as per the requirement. This is an example of existing goods. It means during the time of contract, goods are available with the seller. Existing goods may be either specific goods and ascertained, or we can say another type of is generic and unascertained. Specific and certain goods are those goods which are identified and agreed upon at the time of contract of sale is made. It means this type of goods identified and agreed upon. There is agreement between the seller and buyer for that particular identified goods. So the specific goods. Another is a generic or unascertained goods indicated by description and not separately identified. Means there is a stock of that particular type of product. It means there is a various type of sugar in the sugar shop, loose sugar and packet sugar, 1 kg packet sugar, 5 kg packet sugar, and this is not identified. This is not separate stock of that particular sugar which seller want to sell or buyer want to purchase. It means the subject matter of sale of contract is unascertained, is not fixed. This is the generic or unascertained goods. Example, sale of 1 kg of oil from 100 kg of oil. The merchant, the sale of unascertained goods. When 1 kg is separated from 100 kg of oil, the sale is of specific goods. As we have discussed in the case of sugar. Now next type is future goods, discussed in the section 2 and subsection 6. Future goods means goods to be manufactured or produced or acquired by the seller after making the contract of sale. It means this type of goods is not available with the seller during the formation of contract of sale. Seller acquired such type of goods in future after the formation of contract of sale. Example: an agreement to sell future crops of a particular field implies an agreement to sell future goods. It means seller will transfer the crop or grains to buyer when crop will ready in the field. Suppose that in the case of mangoes, we can make the contract before the season with the seller, and seller will deliver the mango in the mango season. Next type of goods is contingent goods. Contingent goods are the goods the acquisition of which by seller depends upon a contingency which may or may not be happen. Contingent goods is a part of future goods. Contingent goods is not available during the formation of contract of sale. We can take the example where A agrees to sell B a certain painting only if C, its present owner, sell it to him, A. This painting is classified as contingent goods. We can take the example of this painting when A will acquire the painting from C, who is the present owner. In such situation, A will sell or deliver this painting to B. Next topic is condition and warranties. Condition is a stipulation essential to main purpose of the contract, the breach of which gives the aggrieved party right to repudiate the contract itself. In addition, he may maintain an action for damage for loss suffered, if any, on the footing that the whole contract is broken and the seller is guilty of non-delivery. It means condition is essential, main thing of the formation of contract of sale, without which there is no existence of contract of sale and buyer can claim for that. Next, warranty. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives the aggrieved party a right to sue the other party for the damage only and not to avoid the contract itself. It means warranty is something which has collateral. It's not a main thing of the contract. So, in the case of breach of warranty, buyer only can claim for the damage. He cannot repudiate the contract. He cannot revoke the contract. Next topic is doctrine of caveat emptor. The meaning of caveat emptor is let the buyer be aware. It has been discussed in the section 16 of the Sale of Goods Act 1930. Caveat emptor is a Latin term meaning let the buyer be aware. It is a general rule of law that a purchaser assumes the risk of his or her purchase. The intent of the rule is to place a duty of care on the buyer in selecting an item and putting forth appropriate inquiry before completing the sale. In this way, a seller is also protected from liability where buyer's remorse. It means by this doctrine, there is a responsibility lies upon the buyer. That buyer has to explain his requirement, that buyer has to assess his requirement before the purchase, and he have to say about all his needs and requirement in front of seller so that seller can give him an appropriate product. And buyer has also assessed the risk of purchasing a specific goods. There is no responsibility of seller if any problem arises. by the purchase of that particular goods. We can take example, you buy a used car which you are told is in perfect condition, but it immediately breaks down. It means you know about the car, that car is old and car is not a new one. Now there is some exception of doctrine of caveat emptor in case of misrepresentation by the seller. The seller makes a misrepresentation and the buyer relies on that representation. There is a exception. In such situation, buyer will not be responsible. Suppose that we can take the example of car. If seller is selling old car by painting it as a new to the buyer and there is some problem, in such situation buyer can repudiate the contract and claim for the damage. In case of sale by description, as per section 15, the goods are sold by description and the goods supplied by the seller do not correspond to the description. It means when seller is selling something by describing the specific feature of that particular product, when buyer received product, he find that there is mismatch between the description of product and in the actual product. Next, in case of sale by sample, as per section 17, but the goods are sold by the sample and the goods supplied by the seller do not correspond with the sample. If seller is giving sample to the buyer or to buyer and supplies different types of product, it means there is a mismatch between actual delivery and sample. In such situation, buyer can repudiate the contract. In case of sale by sample as well as description, as per section 15, where the goods are sold by sample as well as description, the goods supplied do not correspond with sample as well as description. Fitness for a particular purpose. Section 16, subsection 1. The seller or the manufacturer is a dealer of the type of goods sold by him and the buyer has disclosed the purpose for which goods are required and relied upon the seller's skill or judgment. In such situation, buyer can also repudiate the contract when he finds the good purchased is not fulfilling his objective and he totally relies upon the judgment and skill of the seller. He told to seller the specific requirement of product and seller assured him for the specific performance. Finally, buyer purchased the product and he finds that product is not fulfilling the objective and not as per the description or not as per the promise of the seller. He can repudiate the contract. Next is the performance of contract of sale. It is the duty of seller to deliver the goods and the buyer to accept and pay for them in accordance with the terms of contract of sale. Apart from the transfer of property in goods from the seller to the buyer, a contract of sale of goods visages two other important events: the delivery of goods to buyer and the payment of price to the seller.